The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good morning. 5 cases will be submitted this morning. Those cases are State of Iowa versus Jessica Stanton, Iowa Supreme Court Attorney Disciplinary Board versus Curtis Denbesti, Iowa Supreme Court Attorney Disciplinary Board versus Matthew Knoll, Iowa Supreme Court Attorney Disciplinary Board versus Kyle Early, and Iowa Supreme Court Attorney Disciplinary Board versus Jonathan Sears. And those last 4 cases are now submitted to the court without an oral argument, and will proceed to hear the arguments in State versus Stanton. Mr. Rogers, excuse me.
May it please the court, counsel. Good morning, my name is Aaron Rogers, and I represent the state of Iowa. Over time, many things have changed on the Meskwaki settlement. One thing has not changed. From statehood, the state of Iowa has had exclusive jurisdiction over non-Indians' victimless crimes on the settlement. First, I'd like to address the terminology, tribe member versus Indian, non-tribe member versus non-Indian. Second, I'll explain why the legislation at issue did not change anything regarding the state's jurisdiction. Third, I'll address procedural matters, including that error is preserved, the matter is not moot, and service was effective when it was mailed. Nothing has changed regarding Iowa's jurisdiction, but I'm going to change terminology that I used from the brief to the argument. In looking at the rule governing jurisdiction for crimes arising from Indian country, as Congress calls it, the operative language and the term Indian has independent meaning in federal law. And the first question that you ask when you're determining jurisdiction is an offender an Indian? Is a victim an Indian? And because those terms have meaning, using tribe member could cause confusion and express the court's rule in a way that there appears to be gaps or overlap with jurisdiction where there are no gaps and there is no overlap. So I'd move on from that change to talk about what hasn't changed, and that's the jurisdiction of the state of Iowa. And the jurisdiction of the state of Iowa came along with statehood. It came with the grant of statehood we learned from McBratney. And that case says that even where there's a tribe, even when there's a treaty between the tribe and the federal government that says federal jurisdiction will be exclusive on the Ute reservation there, the grant of statehood to the state of Colorado there changed it, and the Supreme Court said that if the federal government didn't express that jurisdiction would remain exclusive, that the state's power, the fundamental power to exercise its jurisdiction over its citizens who are non-Indians comes along with statehood, and really is the presumption unless there's
make a difference. I mean, reading McBratney, it seems as if in that instance the Ute Indian settlement reservation, whatever it exactly was, predated Colorado statehood. In this case, it appears Iowa became a state in 1846, and the Meskwaki settlement came into existence really thereafter. Does that make a difference?
I don't think so. Actually, no. The grant of that jurisdiction came along with statehood, so the state had complete jurisdiction over crimes by Indians or non-Indians prior to the settlement coming into existence. When Meskwaki Nation returned and bought land from the state of Iowa, and then eventually the state of Iowa transferred that trust land to the federal government, the state of Iowa in that transfer explicitly reserved jurisdiction over non-Indians crimes on the settlement and Indians crimes on the settlement. So, and the Congress affirmed that reservation of jurisdiction of Iowa's criminal jurisdiction. So at the beginning of the settlement, as a federally protected Indian country, as Congress calls it, the state of Iowa had jurisdiction over any crimes on the settlement, and that was explicit. Congress could have.
Well, what was explicit was the reservation. The argument I think that we get from your opposition is that the state should have passed a statute expressly stating that it was going to exercise jurisdiction over the reservation, as I understand the briefing. But and I understand your argument is basically saying, well, no, the state has jurisdiction for crimes within the borders of the state. You don't need a specific implementation statute. Do you understand where I'm coming from? And
I understand where you're coming from, but the express language of the statute that Iowa used to transfer the settlement,
1986.
the jurisdiction, 1896.
1896.
Yeah, right. I keep doing that too. That statute says that all crimes on the Sac and Fox settlement, the state will keep jurisdiction over that.
the state reserves is what it says, actually. The state reserves.
Right, and as a matter of criminal jurisdiction is not something that the state has to exercise or something that the state has to implement. Criminal jurisdiction is the state's fundamental sovereign power to exercise the police power to protect the peace within its borders. And the Solem versus Bartlett case is a good example. On the flip side, that's the case that deals with exclusive federal jurisdiction over major crimes. And in that case, the Congress had in 1908 sold parts of the reservation in South Dakota, and the sale and the transfer of those to Indians and non-Indians of that land, Congress didn't diminish the reservation. It didn't divest the reservation of reservation status. So that didn't change the nature of the reservation. Everybody thought it did. Oklahoma started prosecuting crimes on that land, and the federal government didn't prosecute crimes on that land. And when Oklahoma convicted Bartlett of, I think, attempted rape for a crime on that land, he said, no, that's still Indian country. Federal jurisdiction is exclusive. So the federal jurisdiction persisted. It didn't go away. The federal government wasn't exercising it. Everybody thought it had gone away, but since Congress did not divest the jurisdiction of that status, or did not divest it of reservation status, the jurisdiction stayed. So on the flip side here, Iowa reserved that jurisdiction. That means Iowa had jurisdiction, whether it exercised it or not. It should have. It should exercise its jurisdiction when it has it. But if it doesn't mean that it goes away. And the change.
Counsel, could either the federal government or the tribe prosecute the criminal acts at issue here?
They could not, and that's part of the problem here is that McBratney not only says the state has jurisdiction, it says the state's jurisdiction is exclusive, and the tribe doesn't have criminal jurisdiction over any non-Indian. So a non-Indian's victimless crime on the settlement or a crime against another non-Indian is the state's exclusive jurisdiction, and those crimes can't be prosecuted unless it's by the state.
So if we accept the view of the magistrate and the position of Stanton, we're creating a giant loophole that any non-Indian can go to Tama, go to the casino there, get drunk and disorderly, and they can't be prosecuted. Is that where we are?
That is what it appears to be. It's the state's position that's not where we are, and the magistrate was incorrect. But if this court were to affirm the magistrate's ruling, that's my interpretation of what would happen. Of course, Congress could step in and legislate and say the federal government has jurisdiction, but unless Congress did that, the state's jurisdiction is exclusive. over the.
But isn't that kind of just a make-weight argument? I mean, if you're wrong, then the state doesn't have jurisdiction here. If the magistrate's right, then the federal government does have jurisdiction. I mean, isn't that just another, that isn't really a separate argument, that's just another way of saying your principal argument, right?
I don't know if the magistrate can determine that the federal government has jurisdiction. I don't think that if this court says the state doesn't have jurisdiction, that would give the federal court jurisdiction under McBratney. McBratney said that the federal court doesn't have jurisdiction, state jurisdiction is exclusive. So I don't see how that would work out myself.
Is further factual development necessary to determine whether there was a victim with respect to the no contact order, the violation of the no contact order charge, and the trespass charge?
Maybe. I think that the burden of production on whether there's a victimless crime or whether there's a victim for the crime and whether that victim is an Indian or not, I think the burden of production is on the defendant. There wasn't any chance for the defendant to make that argument here because the charges were dismissed on the day they were filed. But the burden of proof would eventually be on the state. The process for determining that, I imagine it would be a preliminary sort of a hearing that if it's raised as a defense that there's a victim and the victim is an Indian, I think that could be an issue. But
who would be considered the victim of the trespass violation, and assuming it was some corporate entity owned by, I mean, I don't know where it occurred exactly or who owns. I assume it's in the casino property, but
the address on the complaint matched up to the casino's address.
And whatever entity owns that property, what would be the status of the victim in that case, and would that be considered an Indian, or would the property be sufficiently related to Indian interests that federal jurisdiction would attach?
The trespass question is the most difficult one. I think you could look at the statute, and you could look at the no contact statute as well, and say that is a contempt crime. It's not a crime against the protected person on the no contact order, and say that that's really a victimless crime, is a crime against the court's order. For the trespass, Dibble is the U.S. Supreme Court case from the 1840s or so, and says that when New York passed a statute prohibiting trespass on Indian country in New York, that the state's power to protect the peace on that Indian country within its borders was absolute, and I think that is really what trespass is protecting in Iowa. It's under the chapter of trespass or crimes against property, so you could say it's a crime against Indian property, and that's perfectly reasonable argument. But with the Dibble case saying that a trespass prohibition between these two cultures is protecting the peace, I think that's pretty powerful argument that the trespass crime doesn't have a victim, that it's really to protect the peace. But I think looking at the statutory language, you could probably go either way. But we don't have a strong position on how that goes. But I think it's hard to ignore Dibble anyway.
Didn't the magistrate address this as a legal issue only?
Yeah, my understanding is
he saw a change in the law, changed the jurisdiction.
He dismissed, for a lack of jurisdiction, said that the 2018 change divested the state of all jurisdiction on the settlement, but those statutes, the 2018 statute, which repealed the 1948 statute, they only deal with crimes by or against Indians. This is a completely different category of crimes. Those statutes do nothing to affect the crimes here. To get into the procedural issues quickly, error preservation, I think State versus Lastly explicitly governs that. Ms. Stanton moved to dismiss on the grounds that error wasn't preserved, and this court denied that motion to dismiss. So I would leave error preservation at my arguments in the resistance there. The mootness issue is suggested. The magistrate suggested that the case would be moot if it comes back, says that this dismissal was in the interest of justice, and a simple misdemeanor that's dismissed in the interest of justice can't be reinstated. I think Lastly speaks to that explicitly as well, says that a dismissal for lack of jurisdiction is not a dismissal in the interest of justice. And so saying that the case is not moot might be helpful going back on remand. As far as service, there's a suggestion, there's an argument that service was not proper. Going through the rules, you get to Rule 1.442 sub 2 in the civil rules, traipsing your way through the appellate rules and the rules of electronic service. Service is effective when sent to the last known address, and it was mailed to the address on the complaints. And I'll defer until rebuttal.
Mr. Rogers, thank you. Ms. Adams.
May it please the Court, Ann O'Connell Adams on behalf of the United States. The United States would like to make two main points this morning. First, neither the United States nor the tribe has criminal jurisdiction over state law crimes committed in Indian country that do not involve an Indian. Under the rule of McBratney, the United States cannot prosecute federal enclave crimes or assimilated state law crimes unless the crime involves an Indian victim or an Indian defendant. And under the holding of Oliphant, the tribe doesn't have criminal jurisdiction over non-Indians. So authority to prosecute state law crimes belongs to the state when there's no Indian involved, and it always has. Second, the state has always had that jurisdiction, and nobody else has been exercising that jurisdiction from the very beginning. The 2008 Act only eliminated the state's authority to prosecute crimes involving Indians on the settlement. It didn't affect the state's authority to prosecute crimes that only involve non-Indians. To elaborate on the first point, federal enclave laws do apply in Indian country under 18 U.S.C. 1152, and the Assimilative Crimes Act extends state criminal laws to Indian country when there is no on-point federal law. However, under the rule of McBratney, if it's only non-Indians involved in the crime that takes place, the state has exclusive jurisdiction over those crimes. The magistrate judge saying the federal government can do something about this doesn't make it so. If the federal government were to come in and prosecute a crime like the ones here, where there's only non-Indians involved, the case at McBratney, Draper, Supreme Court precedent would say the federal courts don't have jurisdiction over such a crime.
Well, I understand your larger point, but to be a little more granular, the trespass might involve Indian interests at least, and
Sure.
the no contact order might involve an Indian as well.
Sure.
So do you have views on those issues? I mean, there might be, if we accept your view, it would remand it back to district court, but the district court may well ultimately find, as a matter of fact and law, I guess, I mean, that there was an Indian victim, in which case we'd have a different result, right?
I think that's right. And we stated in a footnote in our brief there may need to be further factual finding. The record in this case is extremely limited since the crimes were dismissed right away. I don't have any information about who Joshua is that was protected by the protective order and whether Joshua is Indian or non-Indian. It simply wasn't developed that far. And I think that difference between whether an Indian victim is involved or not is something that will start to develop in the case law now that this jurisdiction has been separated between the state and the federal government. So, the state has made some arguments in its brief that none of the crimes here involve an Indian victim. We haven't taken a position on any of that, and I agree further development could potentially be done there. There's at least one crime, the possession of drug paraphernalia, that's a clear victimless crime. And again, the magistrate's order in this case dismissed the charges because of the idea that the state no longer has any criminal jurisdiction on the reservation whatsoever, regardless of the identity of the victim or the defendant.
Does the government have an official position that it applies across the country with respect to whether or not Indian property, for the purposes of trespass crimes, implicates Indian interests such that federal jurisdiction would attach? And I know there's an old OLC policy position from the 1970s. I don't know if that's still in effect.
Right. I've read the OLC opinion. I don't think we have a view on whether I think you may have to look at the particular state law and what the state law says. There's no official across the country position from the United States on that.
Thank you.
The legislative history of the 2018 Act shows Congress's understanding that it wasn't affecting the state's jurisdiction over crimes involving only non-Indians committed on the tribe's land. The House report says that under the 1948 Act, all crimes on the tribe's land, regardless of the Indian status of the offender or victim, fall under the jurisdiction of the state of Iowa, and that by repealing that act, it would put acts committed by or against Indians on the tribe's land back under federal jurisdiction, as is the normal rule, unless Congress has done something different. The report also shows on page 2 Congress's background understanding that crimes committed in Indian country in which the offender and victim are non-Indians are under state jurisdiction. So I think it's clear from the legislative history of the 2018 Act as well that Congress did not intend to change the jurisdiction on a crime such as this, where a tribal officer presents charges involving a non-Indian to a state court. In our brief, we pointed out some examples of crimes that could be committed on the tribe's reservation where currently nobody would have jurisdiction to prosecute the crime. One example would be a sexual assault in the hotel involving a non-Indian victim and a non-Indian perpetrator. In those circumstances, the tribe could not prosecute the non-Indian defendant. Under the rule of McBratney, the United States couldn't prosecute that crime, and under the magistrate judge's decision, the state can't prosecute it either. We think this is a serious problem, and if there are no further questions, we simply ask that the court reverse the lower court's decision. Thank you.
Ms. Adams, thank you as well. Mr. Daufeldt.
May it please the court. Your Honors, I thank you for the opportunity to present Ms. Stanton's case to you. My brief was brief, and I don't take that lightly, but it was. And the reason that I didn't go into extensive analysis on all the case law, McBratney, Draper, is because the parties in this case and the facts in this case are unique. Okay? Iowa is a unique jurisdiction in the scheme of Indian and state jurisdiction and federal jurisdiction. Okay? It's unique. And it's unique because we have an act that was promulgated in 1896 that precedes the 1948 Act that was repealed here recently. So when I get to this case, and I'm looking it over, and I'm getting a headache, but I'm trying to figure out what did we have prior to the 1948 Act? Because that's gone now, right? It's been repealed. What do we have? We have the 1896 Act. I don't believe my colleagues over here are disputing that that act is still effective. I've seen no repealing of it. It's still in effect. So what does it mean? Well, it first means, if you read the act, it says the federal government has exclusive jurisdiction, period, with the exception that the justices have pointed out on questions. The state of Iowa reserves the right to exercise jurisdiction. They have to do something. They have not done anything in these cases. Nothing. Now, I sympathize with the tribal police.
Isn't the prosecution in this case an act to exercise that jurisdiction, and aren't all the criminal laws on the books in Iowa? What more do we need?
Your Honor, the state of Iowa did not prosecute Ms. Stanton. The tribal police, look at the appendix, look at the citations. The tribal police brought her in under the old rules, thinking prior to December 11th, this is what they did. They arrested individuals. They brought them into state court. Well, that changed, okay, after December 11th. And I think a lot of people just didn't realize we had this act from 1896 that all of a sudden comes into play.
But she's charged with state crimes that the magistrate dismissed, or am I missing something?
I believe they were state crimes, Your Honor. Because if they were tribal crimes, they could not have been prosecuted because, in theory, and this is the other issue, we're assuming that she's non-Indian. And we don't know that. Nobody knows that.
Well, if the arresting officers were deputy sheriffs, then that would have been okay.
Perhaps, Your Honor. Perhaps. But they weren't. We will never get to that question because they weren't. They were tribal police under the jurisdiction of the
tribal
tribe.
police are also law enforcement officers of the state. They're licensed, are they not, under Iowa Code Chapter, was it 80B?
The tribal police are not state law enforcement under 80B.13. There has to be an agreement with the tribe and the state. There's no such agreement. So they are not state law enforcement. That's a misconception that I'm grateful to be able to clarify. So you have a situation, Your Honor, to get back to your question.
Can you tell us, is Miss Stanton, is your client an Indian or not?
In all honesty, Your Honor, I don't know. That question has not come up.
How about Joshua? Do you know either way?
I don't know. I do know this, in looking over the materials in preparation for today, I hadn't caught this at the beginning. But on the citation, there is a circle around a B, which I presume is for race, black, because there's C and whatnot. So, and an I. Does that mean if you circle that she's Indian? I don't know. I didn't create the forms. You know, one of the things this justice has indicated is perhaps we need a hearing on some additional facts, and that may be one avenue. Okay, if you don't find that the 1896 is in play, and that the federal government has jurisdiction, right? So this void that they want you to believe is going to occur, it's not going to happen. If you believe that the 1896 is in play, and no one has made an argument.
Just to clarify your argument, if I understand this right, your claim isn't that the state would lack the authority to assert jurisdiction. You just believe that it hasn't asserted jurisdiction and that the legislature needs to affirmatively enact some legislation declaring the right of the state to enforce its criminal law on this Indian country.
Your Honor, absolutely. That's exactly the point. And because that hasn't happened, federal jurisdiction would have to jump in, and they would have to prosecute these things. Now, the doomsday scenarios, this isn't going to happen because they do have jurisdiction. I would agree that if you go the other way and say that by or against is really the touchstone here, and so, you know, whether it's non-Indian versus non-Indian / victimless, I would concede that paraphernalia is a victimless crime. The other two are completely with victims. But I don't think we get to that question without an evidentiary hearing. I mean, you would have to be able to, and this is really the issue here, is how does law enforcement on the ground decide where we are right now, okay? Where we are right now, how do they decide whether to arrest someone? How are they going to know? If it's non-Indian, and they're right, they've got to, if it's state police or state sheriff's deputies, they need to arrest, correct? But if it's Indian, they don't have jurisdiction. How are they going to know that?
And whose burden is it to establish that they are or are not an Indian at a motion to dismiss stage of this proceeding?
Your Honor, I can't find case law that suggests that it would be the burden of the defendant. As I understand, I've been practicing criminal defense for several years. The state always has the burden, always. So they would have to prove that she's non-Indian. They have to prove that there was no victim or that the other party was non-Indian. I understand what the magistrate did, Your Honors. He saw the repealing act. And it's pretty powerful language in that repealing act. It says jurisdiction ceases for the state. Now, there's an exception, and we respect that argument. But if you're looking at that, you would go, there's no jurisdiction. Dismiss. Okay? Now, maybe you jumped the gun a little bit on that. I can't I wasn't there, so I don't know. But I could see a scenario going forward where you would need to have some factual basis for deciding whether jurisdiction applies. You're going to have to do that. I think recently we had stand your ground legislation come into effect, and we've had hearings on that because you've got to decide that issue before you even go forward with the criminal aspects, case in chief.
Can you address the issue of whether or not there can be, whether these crimes were victimless and whether or not there can be a victim here, and specifically Code Section 91510, which defines victim and specifically excludes simple misdemeanors from the classification of victims within the meaning of the code?
Your Honor, I don't have that code section in front of me, but if that's correct, I'll take your word for it. I think that would be dispositive. I wouldn't have an argument against that. I think that's tough to get around.
Doesn't the Meskwaki Nation, don't they issue tribal IDs, and don't most Indian tribes issue IDs that would resolve the question that you say is so difficult?
Not necessarily. And if you look at ICWA, which is another statute that deals with who's an Indian and who isn't, it really comes down to whether the tribe identifies you as an Indian or not. It could be all kinds of people. I mean, it's not that simple. Whether or not they have IDs, I don't know, Your Honor. They possibly could. But here's the scenario. So if there's an Indian from a different tribe that comes in, right, they wouldn't have an ID, correct? So you still have to decide whether there's Indian or non-Indian. I don't think that's, and here's the thing. If it's just going to be on identification, fine, but that may not be across the board. What if somebody doesn't have their identification? I don't think it's that simple of just merely relying on the fact that someone's going to have proof that they're Indian or non-Indian. So I don't know how that would work, Your Honor. Now,
I want to take you back just very briefly to the question of the authority of the Meskwaki police, and you indicated there was no agreement, and I wasn't aware of the provision you were citing. Was it 80B12, agreements with other agencies, that you think required that before they be a state exercising state jurisdiction, there had to be an agreement of some kind?
Thank you, Your Honor. It's 80B.18. My notes indicate.
80B?
Yes, I'm sorry. I misquoted it.
No, I may have missed it.
There has to be an agreement between the tribe and the state in order for tribal police to be considered state law enforcement. And to my knowledge, take that for what it is, there is no agreement. And why is that important? Well, that's not the state. If they were, you could make an argument that the state did exercise jurisdiction under the 1896 Act by its law enforcement, by extension the tribe's law enforcement, actually arrested these people and set in motion the criminal case. But we don't have that here. The state did nothing. Tama County attorney did not file an appeal. And that brings me to the jurisdictional issue with Lastly. I understand that this body has determined that the state can go forward with this case, but Lastly is distinguishable to the facts of this case. In Lastly, it was primarily, the issue was Indian sovereignty. The defendant stated that he was Indian, and therefore he was immune from prosecution. That's not what we have here. What we have here is straight out jurisdiction. So the Indian sovereignty issue was conjoined with the subject matter jurisdiction issue. And because there was a subject matter jurisdiction issue, you said in Lastly that you could hear the case. That's not what we have here. We have straight out jurisdiction. The magistrate said there is no jurisdiction, period. And because of that, the state needed to go to district court. They needed to file an appeal. They didn't do that. I don't know how you get around that. If they had and lost, I can see discretionary review based on the importance of the question. There's no doubt it's an important question. No doubt. You know, it's always been interesting to me. How do you practically sort out a sovereign nation, quote unquote, within the state of Iowa in the middle of the United States? How does that practically work? And these are the questions that are coming up here today. How does that work? So I don't believe that you have jurisdiction to hear this appeal. I think it ought to be dismissed. And I'll leave it at that. Back to the case in chief. You know, if we can't figure out whether the 1896 Act is actually controlling or not, then I can see an argument for by or against. But I have not heard an argument that says the 1896 Act isn't in effect. So if it is, you have to go by what it says. And what does it say? It says the federal government has jurisdiction except discretionary jurisdiction the state can exercise. And my argument is pretty simple. State hasn't exercised any jurisdiction. And because they haven't exercised any jurisdiction, the magistrate's correct. If the state had exercised jurisdiction, it's a different question. I still believe that there are some unresolved questions that need to be dealt with by the legislature. And I do believe that the legislature needs to step in and decide whether it's going to affirmatively take control over these cases. One other point I just want to make.
Well, there's no legislation that says that criminal law applies in Dubuque County.
I'm sorry, Your Honor?
There's no legislation that says that criminal law applies in Dubuque County.
No, I don't believe there is.
Well, okay, so do we need an affirmative act of the legislature?
No, we don't. But back to the uniqueness, right? We're not talking about Dubuque County being separate from the state of Iowa or the United States.
But ordinarily, when you exercise criminal jurisdiction, you don't have to have a specific enabling act saying it applies within the state, do you?
You do when it comes to Indian country, Your Honor. That's the distinction. You need that. You need a conferring statute.
And the statute doesn't say, and I don't mean to be argumentative, but the statute doesn't talk about discretionary rights to exercise. The statute talks about jurisdiction being reserved, meaning it's reserved from the scope of the 1896 Act. So that doesn't that put us back at the ordinary posture of general application of criminal laws within the boundaries of the state?
Well, subject to jurisdictional law. And that's what we're arguing here today. That's what we're trying to figure out. I would agree. Dubuque County doesn't need a separate statute for the state of Iowa to prosecute in Dubuque County. But that's not the same thing. It's not apples to apples. It's apples to oranges. You have a quote unquote sovereign nation who is. If you go to their website, they're very proud about the fact that they purchased land, like 1847 or whatever it was, and they purchased land so that they could become a settlement. They're not a reservation. And that's unique, too. That's unique to most tribes in the United States. This is a tribe that purchased its own land, and I believe wants to purchase more land because they have relished in the fact that there's a buffer there. And if that's the case, then they need to submit to federal jurisdiction that would come in and be able to prosecute these cases. The state needs to get out of it. I looked at an argument that Justice Marshall in the Worcester case set forth that unfortunately was later found to not be correct. But essentially what he said was, let's just look at this geographical. If a crime is committed on the settlement, on the reservation, it's federal or the tribe. If it's outside, it's the state. That makes it very easy. Because here's the thing. Prior to the Repealing Act, race was not an issue. Okay? Race is not an issue because the state has jurisdiction regardless. By the repealing of this act, you now have race comes into play, and we're trying to sort this out. But race is at issue because whether or not a person who commits a crime is Indian or non-Indian is essential. And whether there's a victim that's Indian or non-Indian becomes essential. How do you do that? practically? How does any law enforcement agency practically do that? I think there are a lot of questions. I think.
Could you return to the issue, or what's your position on the trespass crime? Is the Indian-owned casino the victim?
It's always been, if the victim is the property owner, right? Because they're the ones that are having their rights infringed by the person not leaving. So what's the elements of trespass? Well, you have to be told to leave, and you don't do it, right? So you have to have authority to tell a person to leave. So, I mean, there's the victim. I mean, that's an easy one. You know, as I said, I concede the drug paraphernalia. I don't think that's clearly victimless. The no contact order is a little bit more difficult to ascertain. I would, of course, argue that it's again, you know, there's this broader understanding that there really is no such thing as a victimless crime because society is always considered the victim. That's why a lot of jurisdictions is the people versus, right? In Iowa, we have the state of Iowa. Well, who is the state of Iowa? All of us. We are collectively the victims of a crime. So there's no further questions. I think I've touched on everything. I really appreciate the questions and taking time to listen to my argument on behalf of Ms. Stanton. Thank you.
We appreciate your argument as well, Mr. Daufeldt. Thank you. Mr. Rogers, you may present your rebuttal.
I'd like to start with the assertion that race is an issue. Race is not an issue. Indian status is a political classification, and that is United States versus Antelope, which I cited in my brief, applying the Morton versus Mancari test, which is 417 U.S. 535. The statute doesn't have an exercise requirement. If I can read you the words, it's nothing contained in this act shall be so construed to prevent such courts from exercising jurisdiction of crimes against the laws of Iowa committed thereon. That is not an exercise requirement. That says nothing shall prevent exercise of jurisdiction. I think we're talking a lot outside the record about the way that the Meskwaki Nation police determine who is an Indian and who is not an Indian. I think we can presume that they will act regularly, that because if there's an Indian offender, that they will need to send that person to tribal court, and if it's a non-Indian offender, that it will have to go to state court. I think we can presume that they know and they have a procedure for that. As far as ADB, the sites that I have in my brief, ADB.3, ADB.18, ADD.68, established that the tribal police are sworn Iowa officers with authority.
The claim that some kind of agreement needs to be executed.
I don't think that's in the record. And
it wasn't raised, but what is it in the statute books?
I'm not aware of it, and my understanding is that there is an agreement.
But that's not in the record.
If we're going outside the record, that's my understanding. As far as the burden of production for determining whether it's a victimless crime or not, the case that I cited is Young versus State in my brief, and it collects some cases from
what's
other states.
in or out of the record? If there's an agreement that gives tribal police status to enforce Iowa state law, is that something we could take judicial notice of? And where would we find that agreement if it exists?
I'm honestly not aware of that. If it's statutory or if it becomes part of a legislative record somehow, I'm honestly don't know. If there is an agreement and it's part of the laws of Iowa, I think you could apply it and presume, but I don't know why the Meskwaki police and their determination of the offender's status. I don't know why that makes any difference. Lastly, my friend makes a distinction without a difference, says that that was about sovereign immunity and this is about jurisdiction. That doesn't mean that the state has a right to appeal a dismissal of a simple misdemeanor. The state can't appeal in district court unless the magistrate invalidates an ordinance or a statute. So the order was final in Lastly and here.
Given the recent changes in law, is there an area where there's concurrent jurisdiction between the state and the federal government over certain offenses? And if so, what would those be?
I think the position we've taken is that there aren't concurrent jurisdiction areas between the state and federal government. Up until 1991, I think the federal government thought that crimes by non-Indians against Indian victims, there was concurrent jurisdiction, but the Solicitor General filed an amicus brief in a case in 1991 that said that the federal jurisdiction was exclusive. The authorities are pretty clear that it's exclusive federal jurisdiction, but that's really the only question area.
And if, in this case, if jurisdiction turns on the question of who the status of the victim, let's say in this particular case, is that a question of state law or federal law?
Status of the victim. The state's determining its jurisdiction. So I think the state could.
So what if you had a position where the federal government asserted jurisdiction here and said, for our purposes, we are considering this a crime against an Indian because the casino is operated and owned by, I assume, an entity owned by the tribe? Or who gets to make that determination and what law controls?
Well, ultimately, I think if it's an interpretation of McBratney, this court can apply it and interpret it, but ultimately it would be the U.S. Supreme Court as far as if state jurisdiction is exclusive when it's if federal jurisdiction is exclusive when it's a non-Indian victim. I think those cases are Donnelly and Williams are the ones that suggest that, but the argument against it is it's dicta. It wasn't the issue in the case. So I think that practically I don't think the federal government is going to be asserting jurisdiction, but if it did, it would be concurrent jurisdiction. It would be between two sovereigns, so it wouldn't affect Iowa's exercise of jurisdiction either. With that, I thank the court for this special setting and would ask that it reverse and remand for reinstatement of the complaints.
Thank you, Mr. Rogers. Mr. Daufeldt, thank you again. Ms. Adams, thank you for offering your amicus brief and appearing on behalf of the United States this morning. State versus Stanton is now then submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.